Cameroon's judiciary early this week witnessed a mass shake-up of personnel as judges were transferred in courts across the country. It was an exercise which also included the pioneer batch of common law magistrates that were sent to the northwest and southwest regions. It was a major fallout of the Higher Judicial Council that was chaired by its president, the head of state, His Excellency Paul Biya. The 16-man substantive and alternate members of the council have been told to uphold the independence of the judiciary. If the recent Higher Judicial Council, which comes 3 years after the last, is expected to chart a new course for the judicial system, it nonetheless leaves Cameroonians with a big question whether the judicial system is meeting the aspirations of Cameroonians. That will be our focus on the program tonight. This is Hard Talk. My guest tonight is a former key player in the Social Democratic Front, SDF, who is now president of the Reform Party. He is a senior advocate who has been practicing law in Cameroon for close to 30 years and even more, close to 38 years. Thank you very much, Barrister. Barrister Emmanuel Ashu Agbor, welcome to Hard Talk.
Thank you. Good evening, televiewers. It's a pleasure being with you again.
Sure, the pleasure is shared.
Welcome.
Yeah, you have been in this practice for 38 years and you must have witnessed many sessions of the Higher Judicial Council come and pass. This year, it was still the very scenario. Judges, magistrates were transferred across the country. What do you make of the whole process?
Well, it's a simple redeployment of personnel. You see, the real problem there is that it's a simple show. It's a simple show because how this redeployment is effectively carried out is the problem. Because if you look at it carefully, you'll see that the whole edifice is constructed on a mountain of corruption. Because before this council meets, there are certain stages that have to be satisfied. First of all, the heads of the various courts assess the personnel working with them. That, I mean, the president of the court and the procureur of the Republic or the procureur general.
Wow.
So the procureur of the Republic and the president, they assess. Then all of them send their assessment to the procureur general and the president. Then you have the second stage, which is the meeting of the heads of the various courts of appeals. They meet. And they now make the first proposal for the postings and appointments. And then
and even sanctions, if necessary.
Well, they don't sit as a disciplinary board.
Okay.
They make proposals for promotions and transfers.
Yeah.
Now, their proposals are sent to the Ministry of Justice that also makes its own proposals and sends the file now to the presidency, where the secretariat of the Higher Judicial Council is. So it is after this work is done at the secretariat that the council finally meets to come up with what the public saw. So the problem is that over the years, we've realized that these postings are promotions and transfers are not done as a matter of fact by reason of some competence, some merit or anything. It's because there is some underwater current going around for somebody to be given a post. We had some late person who died at the presidency, and we have stories of a lakeside residence he had in Kribi area there. Any person who wanted promotion would just go there and occupy a room in the hotel, and when he comes out, he calls and says, "I was in room this at the lake."
But are you not talking about particular cases, because the judiciary is also a highly intellectual place where
this has nothing to do with merit.
It has nothing. People must go with merit.
Excuse me, sir. This has nothing to do with merit. I'm telling you that none of those postings or promotions has anything to do with merit. If you are talking about merit, a magistrate or a judge can be appointed because, for instance, he has passed about 100 judgments. Let's say he's in the High Court. He passes 100 judgments. And on appeal, about 75 of his judgments were confirmed. Then you say, no, this man has sound reasoning, sound judgment. But that is not the case. The promotions, first of all, promotions are done because, well, from the proposals that have been made, you don't have any disciplinary file, you don't have any problem, well, that one is automatic. If you don't have any problem, they have to promote you. But now when they have to do the posting to give, you are appointed president of this court or procurator of this place or procurator general, please, those ones, there are things that happen under the ground that the president doesn't know. He doesn't know. They do those things. It is no secret. Every lawyer who works here, you all know that they carry briefcases to your own to go see people so that they can be given posts. So the whole thing is built on, you see, a mountain of corruption. There is no merit in the thing.
Okay.
There's no merit.
Yeah.
If you don't give money, you don't have a juicy post.
Okay, Barrister. We also saw the first batch of common law magistrates. We all know that this has been a very long issue between common law lawyers and the government for judges who are sound in common law practice to sit in the courts in the Northwest and Southwest regions. How significant is this move by the government?
Thank you very much. You see, I feel very uneasy when I hear you talk about that, because these are people, they say, okay, they are common law magistrates. Yes, thank you for giving them the training. But at common law, you don't train judges in any school. You don't train common law judges in schools. They are selected from the bar. So, I mean, it is, when we talk, these people don't want to hear. You don't train common law magistrates or judges in any school. Go to Nigeria. Do you have a school training judges? Go to England. Do you have any school training judges? Common law, when you say common law, they are picked from among the practicing lawyers who have distinguished themselves. So, anyway, we thank them for training our common law magistrates. That will enable us to at least have some young breed coming up that will sustain common law. But they should know that they have to learn to respect the norms. At common law, you don't train judges in any school. They are picked from among practicing lawyers. You see, a judge in a common law system is somebody who has distinguished himself in practice. A lawyer cannot talk to a judge anyhow, because a judge has also already been a lawyer. The judge is a senior lawyer. Senior lawyer. So you see, because the judiciary is one. At common law, it is the judicial system. You don't have lawyers this side, judges this side. No. But they are trying to francophonize our common law system. So that's what they are doing by creating a common law division. They are francophonizing.
Exactly, I was coming to
that.
They are is that a mistake? Is that a mistake for government to create the common law section?
I said they are francophonizing our common law practice. So they should not pride themselves of having done anything, because it is a francophonization of common law. If they want to respect common law norms, they should allow us put in place a system wherein our judges and magistrates are picked from among the practicing lawyers.
Now, the Minister of Justice at the end of the Higher Judicial Council says that the justice system is independent and meets the aspiration of Cameroonians, but that the opinion which Cameroonians have is somehow distorted. Do you agree with him?
I vehemently disagree.
Why?
Because Cameroon is one of the few states in the whole world that has only 2 organs instead of 3. Every normal state has 3 organs: the executive, the legislative, and the judiciary. In Cameroon, correct me if I'm wrong, the judiciary in Cameroon has been put under the executive through the Minister of Justice. You see, the judiciary has been put under the executive. There is no judicial organ in Cameroon. In fact, the government itself says it is it is a judicial. They just call it a judicial. You see,
the constitution says that there's a judiciary in Cameroon.
Which part of the constitution? The judiciary is under the Minister of Justice. The Minister of Justice is the person who is take the side of prosecution. He is the person who is the head of the prosecution. He is the director of public prosecutions. He is the director. Yeah. Now, you go down to the various regions, the Procureurs General are the directors of public prosecution in their various regions. Now, you come to the appointment. You just said it yourself. Who is appointing? The President of the Republic. Is he not head of the executive?
But it's also head of the Higher Judicial Council.
That is what I'm saying. He is head of the executive. So this is the head of the executive taking decisions on the judiciary. You see it?
But
he is the one promoting and transferring people of the judiciary. How can you say it is? The judiciary is not independent.
But Barrister,
let me give you other elements. You see, look, enter the special, the statutes on magistracy.
Magistracy, yeah.
The Minister of Justice has powers to suspend any magistrate of the bench. To suspend. In between two sessions of the Higher Judicial Council, the minister has powers to suspend any magistrate of the bench. So, I'm not talking of prosecution, of the bench.
Of the bench.
Of the bench. He can even transfer them. He can transfer them while the council is not visiting. So the council transfers them and promotes. But the minister has the powers. He can transfer a sitting magistrate from one court to the other when the council is not sitting. And as I said, he can suspend you and even suspend your salary. So how independent is this person whose salary can be suspended by the minister? It is a judge, sitting judge. His salary can be suspended. His function can be suspended by the Minister of Justice.
Now, what is the relationship in clear terms? What should be done in other countries where probably you have seen the experience? What is that relationship between the judges and the Ministry of Justice?
The judges
who plays what power? The
judiciary is not supposed to be under the Ministry of Justice. In fact, the President of the Supreme Court he is supposed to be the head of the judiciary, not the minister. He has no power. Look at the President of the Supreme Court. Now, they take him and put aside, and they say the highest court of the land is the Constitutional Council. You see that? The highest court of the land is the Constitutional Council, which doesn't carry out litigation. It takes care only of electoral matters, special constitutional issues. But the person who is in charge of litigation has been kept out of the administrative process. His powers have been taken away and given to the Minister of Justice. So how do you say that type of person is independent? Now, what do you think a sitting judge who has a case before him and receives a phone call from a Minister of Justice, what will he do? He will say, no, sir. How independent is he when he can be called by his hierarchy on any matter?
Now, you said that the judiciary is not independent, but this is what many pundits have said, that the president who is elected by universal suffrage is given the powers to head the Judicial Council, which takes care of the justice system of those who elected the man who is the president of the republic.
Thank you.
Does that not make sense?
Thank you. I agree with you, but there is something you are losing sight of. The judge or a magistrate is rendering justice in the name of the people of the Republic of Cameroon.
Yeah.
You see, when the magistrate or a judge is sitting in court, he is the fountain of justice. He is the person rendering justice in the name of the people. So he is not supposed to be answerable, because what we are saying here is that our magistrates and judges are answerable to the executive. They are answerable to the executive. Is it not the Higher Judicial Council that suspends them and removes them and even sends them out of office? Sends them out of the profession. Look at, okay, Valentine Justice Valentine Chi, who is now in the US, was just sacked by the President of the Republic, by decree of President of the Republic. That shows you that, I mean, they are vulnerable. They are at the mercy of the executive. A man who is at the mercy of the executive cannot be considered as independent. All
right. Now, how does this play out in the dispensation of justice to the common man?
Thank you. It plays a very, very big part, because now, as I said earlier, the postings are not as a result of any merit, but as a result of envelopes and briefcases of money that have passed. So if somebody goes and borrows money somewhere to obtain a transfer appointment to a certain post, don't you think that when he goes to sit, he will want to collect his money first to pay off his debt?
But Barrister, do you have evidence of the fact that some of these judges give money?
You want me to call names?
No, not yet.
Okay, so that is it. No, what I'm saying, we all know it. Nobody can deny. We all know it. They might be. You see, they may want to sit quiet because of. I mean, out of. So as not to raise public eye crowd. But we all know it. We know it. As lawyers, we know what is happening. So this one, the first impact is that it entertains the corruption, the existence of corruption, because these people look for money to go and buy those posts. And when they are so appointed, they have now to sustain corrupt practices in order to get monies to pay off the debts that are contracted. That's the first thing. In the second place, the man who is up there who controls them, if he sees a matter that interests him, a simple phone call, he will derail justice with a simple phone call. So they are not in the justice cannot be rendered independently in that type of circumstance, where the person rendering the judgment can be influenced by administrative authorities. I want to say that it is punishable under the penal code for the executive to try to influence the judiciary. The judiciary. But in this our present case where the judiciary is part of the executive, you see, you cannot sustain a case. You can bring no case because a magistrate he is under the Ministry of Justice, so he cannot complain against his boss. Now,
what are the values of an independent judiciary? If Cameroon is supposed to have a solid judicial system, one that you are calling for, how should that judiciary be like?
Thank you. An independent judiciary. They say he who pays the piper dictates the tune. An independent judiciary should not, first of all, be paid by the executive. It shouldn't. The executive should have nothing to do with the salary of the judiciary. Because, like I said, the minister has a right to suspend a magistrate and suspend his salary.
So how should the judges earn their salaries?
It is not the executive that should decide. There should be a special scheme for their salaries. They should be independent of the judiciary for the executive when it comes to payment of their salaries. For instance, they can have a special fund in the courts, like all the monies that are being paid in court. The court can pay itself. You see, the courts are capable of paying the salaries of judges. All the monies that people pay as fines when they are in criminal matters, you are convicted to pay a fine. They find you guilty. Instead of saying go to prison for 10 years, they say pay a fine of 10 million. Many people would prefer to pay the 10 million francs and not go to prison. All that money can be put inside that fund. When you bring a matter to the court, you say, okay, I have I'm claiming 10 million francs from this man. You are asked, according to the general tax code, you have to pay 5% of the quotalities as deposit in court to prosecute the matter. Yeah. When you pay that money, at the end, many people don't take their money. They tell you that money is meant to pay stamp duty and all those things. Look, go to the accounts of the various courts in the banks. Go and see how much money is there. Go and see. I was opportune at one time to be sent to the bank to be sec in Bonanjo here by the chief registrar of the Court of First Instance Bonanjo. He asked me, he had to pay one of my clients. So he gave me his checkbook. He said, to go and ask for the balance, account balance, so I can see whether I can draw the check. When I went there, the account was in billions. So, if only one small court can have accounts in billions, join all of them. They are capable of paying those magistrates. They don't need to go and be kneeling down in front of the Ministry of Finance. Anyway, I think that the judiciary should have a separate system of finance. Then two, their control, the discipline of the judiciary. Look, in England you have the House of Lords that has a special chamber that takes care of that. You can arrange for the discipline of magistrates, of judges and magistrates, to be done in the parliament. You can have a special
special commission
in parliament, yes, to take care of that. Yeah. You see, this is what we call the systems of checks and balances. You don't get an executive man sitting there to say, oh, come here, I will punish you, I will promote you. No, that is not checks and balances. That one is instead akin to dictatorship, because in a dictatorship, one of the three organs dominates the others. Like in this particular case, the executive has swallowed our judiciary. You see? So it is akin to dictatorship, which is not correct. The control, that the control of the judiciary is supposed to be in the hands of the judiciary. The appointments and promotions of magistrates should come from the magistracy, not from the executive. Why does the president of the Supreme Court not have the powers to sit with his peers and decide, okay, this man has worked well, let us put him here, or this one should be promoted, sent to this side, or this man is due promotion? They can do it. To show you that they can do it, look at the bar. The Cameroon Bar Association has distanced itself away from the administration. All matters of discipline, the bar is running independently. The magistracy can do the same. Do the same, and the advantage is that if nobody from the government can interfere with the running of the judiciary, the judges and magistrates will not receive phone calls that will influence the course of decisions that are being passed. So that's why we are saying that an independent judiciary is a judiciary where you will have real justice being rendered in the name of the people and not sold. Not sold because, okay, look at the cases. I just take you simple cases. Look at the cases that were brought to court. The military court, the case against Kamto. You saw what happened. Look at the charges. They stopped everything because the president said stop. Had they not stopped, you can imagine what would have happened. What happened to Sisiku and Co? The same charges that were levied against Kamto were levied against Sisiku and Co. Look at what happened. Look at the number of all those judges are appointed by the executive. All civil as well as military. So what type of independence do you want? The man appointing you is the administrator. The person paying you is the same administrator. They give you the orders. When they say run, you run. Stand, you stand. Sleep, you sleep. So the executive should not have anything to do with the magistrates, with the normal business of a court in an independent judiciary. The judiciary should function free of any interference. Now, if there is an independent judiciary, everybody is equal before the law. You see, there are so many cases here when you ask, why is this case not being prosecuted? They say, because the presidency has not yet given the okay. Look at Konak. Konak has the possibility of investigating misappropriation. But they cannot prosecute. They cannot give it to any prosecutor until the presidency says, take that file and give to this person. They cannot. That is not possible in an independent judiciary because any prosecutor, any state prosecutor in an independent judiciary who sees the commission of any offense will pick it. They don't need permission from anybody. He has the freedom to pick the file and prosecute. He will pick it and prosecute because he is prosecutor for the state. He's DPP. He is DPP. Anything that offenses public morals or the law, he will pick it. He does not need permission from anybody. He will pick it and prosecute. You can see what is happening in America. Go to Nigeria here, just next door Nigeria. Look at it. They don't need any permission from President Buhari to take people to court. No. They defend the interests of the law and society. So an independent... Now, look at Kenya. See what happened in Kenya. Where a court sat and cancelled the results of the results of the election. Concerning the president, they cancelled. You cannot do that in a country where the judiciary is dependent on the executive. You see, those are the benefits of an independent judiciary. An independent judiciary will give you impartial judgment. Judgment that is not tainted by favor or fear. But in our present case, let us take our Constitutional Council. When you see all those cases going there, what do they say? Irreservable. They don't go down to the depth of to the matter. No. But they give the reasons why some of those files are not not being received. They tell you that no, this one we cannot sustain it. You throw it want of jurisdiction, want of this. No, sir. Those are cases that ought to be tried. Now, who can carry a case to this Constitutional Council? In an independent judiciary, any citizen has the right. Here, it's only special people. Yeah. You see? And by reason of that, there are so many things that exist that hamper the flow, the smooth flow of justice. You cannot have good justice where only one person, some few people can complain, can seize the court. Why? It's not possible.
Now, for the lawyers, for you people as lawyers, how is that a challenge? How does that relate to your day-to-day functioning with the magistrates when you have some of these hiccups surrounding the lawyers?
Well, the magistrate, he sits in his court, you bring a matter to him. So we know how it functions. And, well, we learn to, you see, when the going goes tough, the tough get going. The tough get going. So we know how to manage our way. If you don't have a file in which special instructions have been handed down, well, you manage your way. Fight it out with the law. And if it becomes very difficult, well, sorry.
And how do you cope with the judges who are sometimes not on seat?
No. How? It's not on seat. How? If it's not on seat, there are others who are there. The court cannot be empty.
But do they follow the law? Do they follow the law in terms of if the main person is not there, the first assistant follows, or the second assistant?
We have very good judges. The problem here that I see you trying to raise, the administration of the courts. You see, there's administration of justice and administration of the courts.
Yeah.
That one has a very serious problem. Because what we see here, you see, the working conditions of these magistrates. When somebody is appointed, it boils down to the same thing. He has bought his post. Now he is going to be out of town. He is afraid that when he allows his first assistant, who maybe did not spend as much as him, or who maybe doesn't have the support of the person who put him there, there will be trouble. So he looks around at the corner and he might go and take the fifth assistant and ask that fifth assistant to deputize in his absence. That is wrong. I'm talking most of the magistrates, they are listening. You see, they suffer from this. Normally, when the president is not there, he is supposed to be replaced by his immediate direct first assistant. And if that one is not there, the second, the third, and so forth. But what we see, many of them leave and they are being replaced in service by not even second, third, maybe fifth. The person in whom they have confidence. That is wrong. In a good system, if he is not even there, his assistant moves into his office. Moves in that office. It is not his personal office, it's the government office, it's the state's office. He moves into it and assumes the function. That doesn't happen. It comes again to the question of missions. You see, because of this corruption, the bosses assign missions only to the people they like, to their own people. I mean, you can have a magistrate or a judge heading a court. There are about 10 assistants behind him. He selects from the 10. Those he likes, and those are the ones he gives missions to. The others remain there looking like orphans. It's not correct. You see, the administration of the magistracy, it doesn't go well. And the bad thing is that the ministry up there has nothing to do. They don't even come down to come and see how it is being done. They don't come. It's not their business. Now, there is another problem. In the administration of justice, the court works with a secretariat. Look, I'm telling you, it is catastrophic. The registrars in the registrars in attendance in the courts. This is a whole body that has benefited from a special status that has been given to them. For 8 years now, they have not had their promotions. No promotion. Their law says they have automatic promotion after every 2 years. For 8 years now, they have had no promotion at all. None. Then, when they are posted to the courts, the people in the ministry post their friends to the big courts in the town, big towns. They overflood the courts in the big towns. And the courts in these suburbs have no personnel.
All right.
When you come to these courts in the big towns, there is no space for these personnel, these court registrars to sit. I take a simple example. Go to Bunaberi or Ondokoti. Bunaberi court has about 100 of them. Look at the court, 100 of them. Many don't even have sitting positions. The worst thing is that when they are posted like that, there is no salary. The salary may come in about 3 years' time. On what are these people going to feed? Look, these are all things that sustain corruption. you go to court and say people should not be corrupt. When the people working in the court there don't have the means of livelihood, why are they not going to use their position to get money from extort money from the public? You see, that is why I say the administration of the courts is a serious problem. Very serious problem. You can't take the magistrate. Look, there is this thing of locus, visit to the locus. It has become a market. It's a big market. You go to the court. There is no law that organizes visit to the locus. What they call here transport judiciaire.
Transport judiciaire.
We have seen cases where the court has to move to 20 meters away. They ask for 300,000. We have seen. They exaggerate and suck the people dry. Any small matter, visit. Mr. Minister, if you are listening, please put your eye on that. Let it end. It should stop.
All right, yeah. That takes me to the next question. What should be done to ensure that the administration of the court is fluid and efficient and void of the practices that you decry now?
Thank you. There are so many things that should be done. When you go to the courts, you will see something that will really strike you. On certain doors, the doors of magistrates, you see reception, 12:30 to this. Who are they receiving? Litigants. Can you imagine? A magistrate who is supposed to be impartial is receiving litigants. He's telling the public that he's receiving litigants from this time to this time. When the people have their cases, they come and see them in their offices. The first thing they should do, a magistrate who is sitting is not supposed to come into contact with the litigants, because that is the occasion on which they get themselves corrupted.
But don't you think the lawyers are also...
they are lawyers as well. The lawyers also should not come in contact with those judges. It's not truly. The lawyers and the parties should not get into... We don't have any business to discuss with magistrates. Magistrates. I am telling you clearly, we have no business to discuss. We should meet in the court hall, not in their offices. I personally, you see, Reform Party proposed that the offices of the sitting judges should be kept away from the public. The public should not have access. So that if you don't have access to these people, there will be no way you can go and corrupt them. Now, you go to their houses, then we can now go to their house and say, okay, every man you have a policeman in front of your door with a register. All those who come there will record their names. Registered. We record their names and how long they stayed inside. So that when we see you in court before this man, we know that something happened. And then look, in the courts, our own system that which operates in sessions is very good, because we can have a judge or a magistrate who will receive all new matters and prepare these matters. When the matters are ready, then the matter will now be sent to the court sitting in session. The president of the court will now invite the state council to come with his own people, call the matter, and appoint a magistrate or judge to go to court with the parties, and they try the matter because it's ready. No adjournment. That way, there can be no corruption. There is no way under the sun you can corrupt somebody whom you never knew. You are meeting for that just there like that, and he goes into the hall, he must finish your case. If they try that one, you'll be very good. Now, take the legal department. The legal department, they say they are in charge of the judicial officers.
The judicial officers.
Go see what is happening. All the police commissariat and all the police stations, gendarmerie brigades, they have become a central market for corruption. In the brigades and the commissariat, they have file opening fees. You bring a complaint, you have to pay file opening fees. You want them to go arrest somebody, special fees. Everything is corrupt. It's very simple. If the legal department has his office away from the court, and they ask that judicial officers be appointed, be sent to work there with the state council in the court, in his chambers. The state council will be the person. His chambers will be the place where investigation is carried out. All the other units should be kept out of investigation. That way, they will now do the work for which they were employed. That is safety of people and property, security, traffic, and all other things that they are abandoning. They are abandoning all those ones and going only towards investigation because there is money there. So we are saying that, this thing can be brought to an end. simply ask that the legal department, which is theoretically the head of the judicial police, and which is having difficulty in controlling those police officers, because there's a unit in the police called Judicial Police.
Yes.
That reports to Yaoundé. They have the director here. He reports to Yaoundé. So this policeman who is working there, how can the state council control him? It's not possible. Dejanam, who is OPG, how do you control him? Take them away from there, like is the case with Special Criminal Court. Take them and put them at the disposal of the state council, so that if somebody is arrested for having committed an offense, they bring him
directly to the state council.
His officers will take the statement, and then he will determine whether the man is going to prison or going to his house. That way, you know that you are putting an end to all abuse that takes place in those various commissariats and brigades, where they catch people. Because somebody says, idiot, they carry you, put in the cell, defamation, insult.
But that could be a contempt of court.
Oh my God. No, somebody in the town, somebody tells his friend, idiot.
Yeah.
They go and give money, carry him, throw there, 1 week. The state council doesn't know because the commandant has taken his money and wants to satisfy the person who give him money. It is wrong. You can bring all that to an end by simply asking the state councils to work in their offices with the people who are in charge of recording the statements. So that one is a very simple thing. Now for the magistrates, as I said, look at their offices. It's very simple. Most of their offices are in the corridor. Just put a door at the corridor and put a magnetic card. Access to that place is limited by the magnetic card. Nobody will enter there, and that way you are sure that no money flows inside that place.
All right. Now,
all those ones don't require any decree from the president.
Just a proper functioning.
Simple.
All right, Barrister, there has also been this problem coming from the courts, the issue of the delay in court cases. What is really the cause, and what do you think could be done to put an end to it?
Now, delay in the judicial process is, well, it depends on several factors. Let me take the Francophone system here, where their writ of summons is called assignation. For the matter, a civil matter, to be ripe for hearing, that original writ of summons has to be stamp duty and brought to the court. When you stamp duty it and bring it, that's the time now that the magistrate or judge has the right to say, okay, we are proceeding. Until that, he will adjourn the matter for that document to be brought. That is one of the first reasons. The second is at the instance of the parties. The parties themselves. You are complainant. You bring a matter to court. You are the one who comes again and tells the court, I want an adjournment to go and bring documents. You ask 2-3 adjournments. Then your opponent also asks 2-3 adjournments to answer. Like that. You find yourself, one small matter, you are 1 year adjournment every day. You turn around, many people will turn around and accuse the magistrate for nothing. It is the parties who are obtaining the adjournment. Again, I'm a lawyer, but I think I have to tell the truth. There are some lawyers who have this bad practice of adjourning matters to get money from clients.
Money from clients.
I will not hide it. Some of us do that. We cause matters to be adjourned. You see, you have few cases, but you know that by reason of the exposure you have in court, you can have the opportunity of having more cases. So when you go to call your matter, you do everything so that they adjourn it. That enables you to come to court again another time, and the client pays you. And it puts the judge in a very difficult situation. Good. So I want to say the magistrates and judges are innocent of that one. They are not the people responsible for that one. It is the parties, in most cases, it is the parties that are responsible for the adjournments. It is them, because I don't see the magistrate or judge who will take pleasure in adjourning, because they have strict instructions from the ministry. They want to have they have to reach a certain number of judgments they must pass. Yes, so they don't have an interest. In fact, they are always wanting to go ahead, but it is the parties who say no, I don't have this. Well, then there are other cases like somebody that is homicide, somebody is dead. Okay, you have to bring death certificate, and this, then it does not come. It does not come. Or you have somebody who is in prison, the death certificate doesn't come. They keep adjourning. You see, things like that don't depend on the parties or the court. Those type of things. You see, there are things like that influence the speed with which judgments are supposed to be passed. You can name. There are many things that can influence, but I don't see any court that will take pleasure in adjourning matters. No, I've not seen.
Okay, Barrister, there's also this issue that was brought for this week with the Higher Judicial Council. It is holding 3 years after the last in 2017, and meanwhile, the one which held in 2017 held 2 years earlier, 2 years after, which was in 2015, whereas the law says that it's supposed to hold at least every year. Does that have an incidence on the situation of justice in Cameroon?
It does have, because let us look at a simple thing. Look at the personnel. People are supposed to go on retirement. As when they reach the age, they go.
They go.
Okay. The ministry has looked at that and said, okay, we shall train magistrates from the school so that every year we send them in. This council that just said, you look at the number of, you look at the intake, it's 3 batches of ENAM. You see that? So you have these people who have been waiting for 3 years to be sent into active service. How do you feed yourself? Just look at it. You have been trained as a magistrate. For 3 years, you sit there waiting to be posted. How do you feed? Look at the ordeal that they have just gone through. All those people have waited for 3 years to be posted. I don't want to tell you the type of justice they will go and render.
Go back to the corruption cases.
They have to replace what they did not get. And then before their salary starts coming, look at the ordeal. They will have to run to Yaoundé. How many years before they start getting money? No. It's really difficult. So you see, that delay in the holding of the Higher Judicial Council impacts the functioning of judiciary. And you see, I would like to say this. I personally think the Higher Judicial Council is a misconception. Because when you look at the Ministry of Justice has 6 departments, or takes care of 6 different professions. You have magistrates, court registrars, lawyers, bailiffs, notaries, and then penitentiary administration.
Warders,
Now, they come up with something that looks like the highest body in the ministry. They say it is only in charge of the magistrates. Now, there is no other body in that place that takes care of the interests of the other groups, of the other 5. Had it not been that the lawyers had the Bar Council and that runs its affairs, lawyers would have also been inside. Because of this, look at the bailiffs. We have bailiffs who have gone on retirement without being posted, without being assigned at all. They have gone on retirement. They call them the sacrifice generation. Why were they sacrificed? The same thing with notaries. I just talk about the court registrars. There is a law that enables them to enjoy a bit. It is not being applied. And because there is no decision-taking organ in that ministry, their case cannot be brought to the limelight. The same thing with penitentiary administration. The warders, in 16 years, warders have been promoted twice. In 16 years. Court registrars, 8 years, no promotion at all. And then when you come to the postings, terrible. If you are not a friend to this one, you will not be posted somewhere. Go to the courts. You will see administrators of the registry working on that principle. I mean, somebody who is less experienced than another is up there, and the other ones are under him because they don't have umbrellas. Okay,
Barrister, just before we go now, you are a political party leader. At the level of the Reform Party, what are the reforms that you have mapped out to ensure that the justice system is clean and void of the vices which we have been discussing?
Thank you very much. I will take this advantage to announce the creation. Today we inaugurated our first external cell in Chad, in N'Djamena, Chad. It was installed today, and the second will be installed in the Central African Republic in the days to come. So I just mentioned some of the measures that the Reform Party has put in place. We have a plan of action to end corruption in the judiciary. End corruption. In fact, Reform Party, we have to apply that project. The first thing we want is that you cannot train somebody as a magistrate. He works for so many years. Then you come and look at the salary. Their salary is a shame. It's a shame. Look at how much are they paying them. You ask people to pass judgment on matters that are in billions, and you pay them like 100 and something thousand, 200, 300. It's a shame. The basic salary of a magistrate should not be less than 1.5 million. Let us look at the case of Gabon, the example of Gabon.
All right, just briefly, because we're about to go.
Gabon, yeah. 1.5. Then, like I said, the magistrates where they're working the sitting magistrate should not receive lawyers or litigants. Then we should have this system where the court sits in a session and the parties come and they appoint the press people to go to court with the parties. You try the matter, no adjournment. And then the session, we are still living in the dark ages. Today, they still give you, the president of court will write inside the register, please, let us upgrade. Let's upgrade. We should integrate video in the justice system, because there are so many abuses that take place inside the court. If there is video that is integrated, if you appeal, your DVD should accompany the file, so that the court of appeal will view the images of what happened down there and look at what was written.
And have a better appreciation. All right, thank you very much, Barrister. It was a pleasure to have you. Yeah, Senior Barrister. Thank you very much.
You're welcome,
and to you, televiewers, it was a pleasure being with you on this edition of Hard Talk. Until next time, bye-bye.